Recording in progress.
Okay. Good afternoon, honorable members. Good afternoon, parliamentary staff that are here, including our legal advisor. I am chairing this meeting on my way to the airport, and I would wish that I participate in this meeting until to the end, which I really doubt if this meeting will be long. But let me start by welcoming you and saying in this meeting, I take this meeting to be virtual, but also to be in the precinct of Parliament. Please allow me not to show my video as I'm driving and on my way to the airport, planning to be in Cape Town tomorrow. And hopefully that this meeting should proceed up to just before 3 o'clock for me to board to go to Cape Town. Welcome, honorable members. Let us start by observing a moment of silence and meditation. Thank you very much. Ms. Machalamba, can you indicate to us, honorable members that are present in the meeting and those that have given apologies?
Good afternoon and thank you, Chair. Present is Dr. Dlomo, Ms. Keko, Ms. Shabangu, Ms. Sine, Dr. Leroux, Mr. Mutubatsi, Mr. Mchatu, and Mr. Zungula. Chair, I've received apologies from Ms. Clark, Mr. Van Staden, and Ms. Mhlongo. Thank you, Chair.
Okay. Honorable members, this meeting is convened to consider one item, and I would wish that Mr. Machalamba can, sorry, somebody's on there's someone who wants to speak or who's Honorable Mutubatsi, your camera, not your camera, your gadget is on. Can you please mute? Mr. Machalamba, can you show us the agenda? Thank you. After this presentation by the chairperson, there will then be Ms. Sue Isaacs will take us through a document that probably most of us are familiar with that has been sent to our platform. If not, while maybe I make my comments, Ms. Machalamba, if you could then make sure all members see that presentation. Then may I request there will be a slight amendment to the program. After the presentation, without really writing it down, allow me to bring up an item related to the same one, which was then brought to my attention by the chief, not the chief, by the House Chair from the Chief Whip of the Action SA just 30 minutes before we start this meeting. So that one I'm going to report on it. Ms. Machalamba also did not know, she did not have it here. So my slight amendment and the desire to adopt this agenda is with this amendment to say a discussion and an input of Action SA received from the House Chair to me just now, 30 minutes ago. If that could be also agreed to in this committee, that I insert that just after the legal opinion, can I get a request I'm making agreed upon by this meeting? If so, may I get a hand?
You have my hand up, Chair. Good afternoon to
Good
members.
afternoon.
Yes,
Yeah.
I'm raising, Chair, my hand in order to support what you have just alluded to. It's in order. So the agenda must proceed as such. Thank you.
Any honorable member agreeing with the amendment that I've proposed that has now been proposed by formally by Honorable Tembalami Sheila Xhego.
Chair, I'm happy for us to go ahead in that way. Thank you.
Thank you very much for the support. Thank you. Okay. Honorable members, the purpose of this meeting is to consider just one item. In one of the meetings we've had during the public hearings, Honorable Dr. Letlape raised a matter that he was related to one of the stakeholders who were presenting or were going to be presenting on that particular day. And firstly, let me just indicate that this part I'm going to raise, I'm going to end by saying it is my considered view and also supported by the officer higher than me to say I should ask Dr. Letlape to recuse himself from this meeting. If he does join and he's actually supporting that coming in from the higher office, that he should recuse himself from this meeting. Anyway, as I'm starting now, after that issue he raised, we could not adjourn the meeting, wanted to adjust there and there. I raised an issue with the committee, which was agreed upon that maybe for that day, for that presentation of that institution that was associated with him by him being the founder, he should recuse himself by being part of the meeting, but not to participate in the clarity-seeking comments, statements, or any other issue with that for which he complied with. I then subsequently reported to the office higher than myself. As the chair, I have a house chair I report to. And that issue then was taken up by my by the house chair, Honorable Frolick, who has been going to and fro with this matter. Among other things that he did was to involve the Action SA chief whip. And the discussions that took place then was that the Action SA chief whip will write a letter to Honorable Frolick indicating their stance, which he had communicated to Honorable Frolick verbally. So days were passing and I keep on saying, three times I phoned Honorable Frolick yesterday. Honorable Frolick, we have scheduled a meeting for 2 o'clock today. Please, can we get your response at the discussion you have with the Action SA chief whip? That was not forthcoming until just about then 30 minutes ago when then Honorable Frolick forwarded me a letter, which then I'm going to read to you, not in the spirit of their discussions earlier on with that chief whip. So that letter is here now in the platform, will be at item number 3 after my opening remarks of something that most of you honorable members are familiar with. That is how we handle that matter. That after we closed our meeting, I referred the matter up to House Chair, who has since processed it with the party chief whip, as raised by Dr. Letlape. And the response is then, among other things that he did was to also get a legal opinion from Parliament, which now I will ask Ms. Sue. All our discussions will come thereafter. Ms. Sue, to take us through that legal document which your team and yourself involved prepared. Can I invite you, Ms. Isaacs, to take us through that document now? Thank you.
Thank you, Chairperson. I am Suan Isaac from Parliament's Legal Services, and as you indicated, I will just read out the opinion for you. Chairperson, this opinion is titled "The Possible Conflict of Interest Related to the Tobacco Products and Electronic Delivery Systems Bill." The Portfolio Committee on Health was requested the Constitutional and Legal Service to provide legal advice on a question of a possible conflict of interest that has been raised during the processing of the Tobacco Products and Electronic Delivery Systems Bill, B33 of 2022, which is called the bill. The below discussion is in response to that request as per the background information provided as context to our office. On 24 July 2025, the committee held public hearings on the bill. One of the organizations that made oral submissions to the committee was the Africa Harm Reduction Alliance, AHRA. Before the presentation, a member of the committee, Dr. Koshi Letlape, disclosed that he was the co-founder of the AHRA and that he would not engage with the presentation. The chairperson consequently asked the other members of the committee if anyone objected to Dr. Letlape remaining in the meeting during the presentation. No one objected to his continued presence. Chairperson, the legal question that we were asked to consider is, for the purpose of this opinion, the legal question can be phrased as follows. What are the parameters of a conflict of interest, and how does it affect the committee's processing of the bill in light of the member's disclosure that he was the co-founder of the Africa Harm Reduction Alliance? The legal framework, we first refer to the rules of the National Assembly. Rule 30 of the rules of the National Assembly addresses the declaration of private interest and provides as follows on obligation placed on the members. If a member has a personal or private financial or business interest in any matter before a forum of the assembly of which he or she is a member, he or she must, at the commencement of engagement on the matter by the forum, immediately declare that interest in accordance with the code of conduct contained in the schedule to the joint rules and comply with other provisions of the code. Clause 6D and E of the Code of Ethical Conduct and Disclosure of Members' Interests for Assembly and Permanent Council members, the code further provides as follows. A member must, and specifically D, declare any direct, personal, or private financial or business interest that the member or any family member or the member or any business partner of that member or business partner of the family member of that member may have in the matter to be considered or decided on before any parliamentary committee or other parliamentary forum of which that member is a member or in which that member is participating. And E, withdraw from the proceedings of the committee or forum when the matter is considered or decided on, unless the committee or forum decides that the member's interest is trivial or not relevant. Moving on to the discussion, Chair, and some of the information contained in this discussion is what was publicly available on the website of AHRA. So Dr. Letlape is the president and co-founder of AHRA. The person who presented to the committee during public hearings on behalf of AHRA was Dr. Delon Human, who is the CEO of AHRA. The AHRA promotes tobacco harm reduction. The AHRA states on its website that THR, which is tobacco harm reduction, is a strategy aimed at moving tobacco smokers to potentially less risky nicotine alternatives, such as e-cigarettes, vaping, or nicotine pouches. Accordingly, its website describes its associated mission as follows. The Africa Harm Reduction Alliance brings together leading harm reduction experts in the medical community. It is our mission to reduce drug, alcohol, and tobacco-related death and disease in Africa by educating policymakers on the benefits of harm reduction policy. This website has been developed with seed funding provided by Health Diplomat and individual donors. Since the AHRA website is placed for public funding, it welcomes donations and funding from its supporters and individual donors. Dr. Human is also the CEO of Health Diplomats, which provides seed funding to the AHRA. Health Diplomats describes itself as a specialized health, nutrition, and wellness advisory group. Health Diplomats also provides services including strategic counsel, advocacy, communication, government relations, and corporate affairs and stakeholder engagement and alliances. Now, turning to the rules of the National Assembly, NA Rule 30, read with Clause 6 of the Code, requires that members declare any direct, personal, or private financial or business interest or of a business partner that may have an interest in the matter to be considered or decided on before any parliamentary committee on which the member is a member or in which the member is participating. So read, the NA Rules and Code places an onus on the member to disclose conflicts of interest. The bill seeks to regulate smoking, including the regulation of tobacco products and electronic delivery systems such as vapes. Dr. Letlape is the co-founder of an organization that advocates for tobacco harm reduction. AHRA receives funding from health diplomats and other undisclosed donors in pursuit of that harm reduction mission. Further, Dr. Letlape's business, a partner, Dr. Human, may also have an interest in the matter, both as CEO of AHRA and the CEO of health diplomats. On the face of it, Dr. Letlape may have a personal or private financial or business interest in the matters that the bill seeks to regulate. If this is the case, Dr. Letlape should have disclosed the nature of his interest at the start of the committee's processing of the bill, as required by NA Rule 30, read with Clause 6 of the Code. If there is a conflict of interest, the provisions of Clause 6E of the Code are applicable. The member must withdraw from the proceedings of the committee when it considers the bill. Alternatively, the matter must be put to the committee, which must decide whether the member's interest is trivial or not relevant to the processing of the bill. In the interest of ensuring the integrity of the processing of the bill, Dr. Letlape should be made aware of this concern and be advised to disclose any potential conflict of interest in respect of the bill to enable the committee to consider to what extent such an interest stands to impact the validity of the legislative processing of the bill. In conclusion, based on the above discussion, our office holds a view that Dr. Letlape may disclose any potential conflict of interest in respect of the bill, given that he is the co-founder of AHRA, which is an organization that advocates for tobacco harm reduction, and AHRA receives funding from health diplomats and other undisclosed donors. On the face of it, it would appear to be it appears to be the conflict of interest in the specific case. Thank you, Chairperson. That is the opinion that we have provided for you, for the committee's consideration.
Right. It's a legal opinion, but it sounds to me a straightforward English. But members may, because Honorable Ms. Isaacs will stay with us until the end of the meeting. I did indicate to you, honorable members, that the discussion that has been there between having elevated the matter to the House Chair was that there was a discussion between the House Chair and Action SA Chief Whip, and he was awaiting a document, a response, a letter, which they discussed verbally from their discussions. That is, I'm now opening up the discussions between the House Chair and the Action SA Chief Whip. But then instead of getting a letter addressed to the House Chair from their discussions from the Chief Whip of the Action SA, what has subsequently happened was the Chief Whip was the House Chair receiving on my behalf a letter from Dr. Letlape to address to me, which I have now since forwarded it to the group. That letter is from Dr. Letlape, sent to me, but received 30 minutes ago, coming in from the House Chair. The topic is that possible conflict of interest related to the Tobacco Products and Electronic Delivery Systems Control Bill. I must indicate that this letter from the Action SA letterhead from Dr. Letlape is addressed to have been written on the 29th of August 2025. But again, to reiterate today, I got it 30 minutes ago from the House Chair who was expecting a letter from the Action SA Chief Whip, but instead got a letter from Dr. Letlape, which he has since sent it to me. Dear Honorable Chairperson, upon receipt of the legal opinion, so it looked like they are responding to what Ms. Sue has written. Upon receipt of the legal opinion from the Constitutional and Legal Services Office, I find it important to write to you in the interest of transparency and to ensure that that the record is properly clarified. With reference to the applicability of clause 6 brackets D and brackets E of the Code of Ethical Conduct and disclosure of members' interest for assemble and permanent council members, I respectfully submit that clause 6 and brackets E applies and that the matter is in question does not amount to a substantive interest. My past association with an entity I co-founded is, in fact, trivial and not relevant for the following reasons. One, my association with the reference entity, which is called Africa Harm Reduction Alliance, predates my election to the 7th administration. In brackets, the abbreviation AHRA is a non-profit advocacy organization with no financial or business dealings that would in any way benefit me personally. As such, clause 6D, which specifically refers in inverted commas, personal or private financial or business interest, is not applicable in this instance. My representation in Parliament, including the policy contribution I make, is guided strictly by my policy position of the Action SA, the party on which list I was elected. My participation in any parliamentary committee is therefore informed exclusively by my party's position and not by any prior involvement with organizations. Indeed, as my curriculum vitae reflects, my career has spent numerous professional and advocacy associations, none of which bear overriding relevance to my current mandate as a member of parliament. In light of the above, I respectfully submit that the matter of conflict of interest raised in this regard be considered trivial and irrelevant, and that my participation in this work of this committee continues, as has been the case without objection from members. Signed by Dr. Jose Letlape, Member of Parliament, member of Action SA. Now, I would then, as the agenda reflects, expects members to comment, give guidance. There's a legal opinion from Parliament. There's a response of Dr. Letlape to the legal opinion, and we then need your input, honorable members, as members of this committee. I will recognize hands as they come up, and I'll give you numbers to comment. Honorable members, there's a first hand, is that of Honorable Dr. Leroux. There's the first one. Now we are number 1. So there's only one member who's going to talk.
Chair, could I just, my point is just a point of clarity on the
My hand is
presentation.
upstairs.
You'll do that. Clarity maybe from the legal. The second hand is that of Honorable Shabangu.
Also, Kweko's hand, Chair.
Kweko always
Mind
struggles
my inability. Yes, mind my inability.
to raise a hand. Honorable Kweko, you are
Yes.
number 3. Yes.
Okay, Chair.
Will I leave with those hands so that we have one round? Honorable
Chair,
Zungula. Number 4.
also my hand is up, Chair.
Yes, Honorable Zungula is up. Honorable, okay, now Honorable Zungula number 4. 1, 2, 3. 3. Number 3 is Honorable Kweko. Number 4, Honorable Zungula. Number 5, Honorable Motubatse. Any other hand? None. I have got those hands. Others are clarity seeking. Some of them probably are commenting on this. Let's start with Dr. Leroux, who talks about the clarity seeking. Number 2 would be Honorable Shabangu. Number 3, Honorable Keko. Number 4, Honorable Zungula. Number 5, Honorable Mutubatse. Thank you.
Chair, thank you very much. I'm not sure if the legal representative might be able to answer straight away. I'm just scared that if we have 5 questions, the specific question that I'm asking might be lost in the discussion that might follow. And I might also still, once I have clarity, want to make a comment or give feedback on this later. But could I just ask, I am not 100% understanding the legal recommendation. So the one thing I'm hearing from the legal opinion is that they are concerned that there might be a conflict of interest that should have been declared at the beginning of the process. And the second point I'm not hearing is I don't actually hear what the recommendation is of the legal advisor. What do we do from here? Because and the third thing is that from what I'm trying to understand is that we all heard that Dr. Leklape did, at the very beginning of the session, declare his that he had a link to the organization involved, which seems to be appropriate. But I and from his my concern is that I'm not entirely clear what the legal representative is saying, because again, it seems to be based, we don't know what the financial interest, if any financial interest is there. So there's not been a finding made from the legal opinion whether this is a significant conflict of interest or not. And I feel that we haven't been given enough guidance on this point. So I really would like to get clarity on those things. Number one, could they find that there's a financial interest or conflict of interest? Should this have been declared at the beginning? If this is indeed the case, how does this affect our whole process of our of this all the hearings that we've been having? And so I'd just like to get clarity around that, please.
Okay. Let's start with that before we move on to the other ones. Legal opinion, what is your real recommendation to us? But Honorable Leroux, bear in mind that legal opinion did not do investigation. They were actually getting reports of what transpired in the meeting. So they did not sit down and say, this is an issue, come and address it to us. So the opinion is not formulated on the basis of having had any investigation or a commission that was set up. It was on the basis of the reports that were forwarded to them via the Honorable House Chair, having discussed with me. So there's never been any investigation done by them. But let me ask them first,
Thank you.
What are you crystally saying? What is your crystal message on the issues of your recommendations? Bearing in mind that Dr. Leroux might then still come back based on that. I will give you that leeway, but you probably towards the end again if the clarity. Start on Ms. Sue.
Thank you, Chair.
Isaacs.
Thank you, Chairperson. Yes, Chairperson, as you clarified, this opinion was drafted with the intention of giving Dr. Leklape an opportunity to respond to the prima facie kind of, evidence or matter that was brought to our attention. So with regard to what should the committee do, I refer the members to the Code of Ethics, which is clause 6D and E. So it states that a member must declare any direct or personal or private financial or business interest that the member or any family member of that member or any business partner of that member or business partner of the family of the member or that member may have in the matter to be considered or decided on before any parliamentary committee or other parliamentary forum of which the member is a member on which that member is participating. It's a bit long-winded, but basically it says you need to declare where there is some matter you may be conflicted, including its direct, personal, private, financial, or business interest of yourself, your family member, or a business partner. So if there's some sort of link and it creates a conflict, then you need to declare it. And then the second part of this is in clause 6E, it says the member must withdraw from proceedings of the committee or forum when the matter is considered or decided on, unless the committee or forum decides that the member's interest is trivial or not relevant. So if the member on their own accord realize they are conflicted, they must bring it to the committee. They must either on their own withdraw, or they must put it to the committee and substantiate that this is trivial and not really relevant to the matter under the discussion. The committee must agree that that is the case or not. So the first option is the member withdraws. The second option, that the member must indicate that they have a conflict, but it is not of such a substantive conflict that it would affect the process, and the committee must make a decision on that regard. Thank you, Chair.
Okay, thank you very much. Next member, Honorable Shabangu.
Video. Thank you, Chair. I'm also not going to open the video because I'm in the transport, but I'm alone. And I will just be quick. And guys, I will just go straight to what is the point of contention on the table. I hope and believe that Dr. Leshape one is not in this meeting like we indicated when we started. Then, based on the advice and the legal team that has been presented here, I think on the day of
Honorable Shabangu,
let me get away from these people.
I give you another. If I jump you to
Please,
Honorable
last time, let me just quickly finish quickly, Chair. Based on what the legal team has advised us on, I think it's clear that Dr. Leshape had a conflict of interest. And to be fair, he was supposed to recuse himself from the beginning of the public hearing, not to declare only when the company that he founded was there to present. So for me, he hasn't done justice to this committee for sitting complete or attending all the public hearing without declaring, because he was not supposed to be part of this committee. So the advice that has been given by the legal team, I think Dr. Leshape is not supposed to continue with this committee based on what is said legally. So he wasn't supposed to be there from the beginning. I'm sorry for the noise, Chair. Thank you for the opportunity, but honestly, as a parliamentary, Dr. Leshape wasn't supposed to be in this committee. Thank you. Thank you very much. Thank you very much, Chairperson. Good afternoon to you and the members connected to the meeting. Chair, thank you very much to you first for escalating the matter or your clarity seeking to the House Chair about the matter. I think I take note of the legal opinion received, Chairperson, and I can summarize say Dr. Leshape has conflict of interest around this matter. Why I say so is because the organization that he co-founded is in alliance with other organizations. So there may be other organizations that participated in the process of this bill where he also took part. I am not sure. I am using
the word may be. It means that needs to be investigated if there are no other organizations that participated that are linked to the organization that we are talking about now. Also, Chair, regarding that, I just want to add something that says it is unfortunate also that you have just received a communique from Dr. Leklape just before we start with our meeting, because what I would recommend at this moment is that we also seek a legal opinion based on what he has just communicated to you, because the previous legal opinion was based on the earlier concern that we had as a committee. It's good that Dr. Leklape was exemplary before the start of the meeting to disclose such information. But this disclosure does not stop us in investigating which organizations are linked to this one that he co-funded, because the communique is saying it's an organization that even represent interests of other organizations that they are in alliance with. My closing statement would be that let the matter be referred to the legal department of Parliament, and the situation remains the same as based on the legal opinion that we've just received. And I am saying there is conflict of interest around this matter. To me, it means, Chair, the Action SA is not bad as an organization, is not bad from participating in the process of this bill. Who may be bad is Dr. Leklape, who has a direct interest and a conflict of interest around the matter. Thank you very much, Chair. I submit.
Thank you, Honorable Zungula.
Good afternoon, Chair. Afternoon also to my colleagues. Perhaps as a point of departure, Chair, I would say it is, I don't think it is prudent that we discuss something that is based on a legal opinion or that has got legal implications, having received documents on the a few minutes or during the meeting. I'm saying this because we need to apply our minds, and we also need to consult legal advisors to the different political parties, because we're dealing with a legal opinion. It is not a political matter where we can just express ourselves politically speaking. In that case, I want to agree with Honorable Teko to say perhaps what should be done is to give all of the information to the legal division, so that when we have a legal opinion that will be thoroughly engaged by the committee. Firstly, it has all of the facts, so that we do not speak and then say we think this, we think that, whereas we should be dealing with matters of evidence and facts. That is the first issue. The second issue, perhaps, that needs to be spoken to by the lady who drafted the legal opinion is the definition of a personal conflict of interest, especially in this case, because one would argue if you are a smoker, therefore you should not take part in all of the deliberations of the bill, of the tobacco bill, because you've got personal interest as a smoker, or if you are vaping, or maybe if you had a family member that died because of tobacco-related illnesses, there's that conflict of interest because of that, because of the personal conflict of interest that you have. So I think it is very important that we get proper definitions as to what would constitute conflict of interest in the context of the bill, so that we don't deal with the Dr. Letlape issue. Yet, if me, I'm a smoker, another member would feel that I've got a conflict of interest, and then only months later, my issue comes across, and then it has to be dealt with at the time. Similarly, on the question of the private financial interest, every year we have to disclose to Parliament or declare to Parliament about our about our financial interests. If one owns a spaza here or owns any establishment that sells cigarettes or tobacco products, is a financial interest maybe that needs to be processed? Perhaps they should be. Also, if you are a shareholder in any company that may own any that may be downstream, there could be a company that is selling or involved in the sale of any tobacco products. Also, that would mean there's a conflict of interest there. So the other question that I would have is that if there is a conflict of interest that makes a determination to say Dr. Letlape must not be part of the process going forward, what then becomes of the other processes that he was participating in the past? Must all of them be redone? And what are the cost implications of that? And the reason why I want to go back to the point of saying that we need to establish the facts is it factual that Dr. Letlape has got financial interests? Because if there's a case that he's a co-founder of an NGO, it is a not-for-profit organization. Therefore, there could be no financial interest in my understanding. So in conclusion, Chair, my submission would be to say, let's establish all of the facts to be given to the Legal Division of Parliament, and then have the Legal Division of Parliament go thoroughly with everything that is going to be before them. And then before the next meeting is called, where we can make an informed decision, then we are finished with the legal opinion, whereby all members can have an opportunity to engage their respective parties and their respective legal advisors on that legal opinion before we make a decision. Any decision that we can take today would be premature because we do not have all of the facts, and we are not in a position to make a determination whether Dr. Letlape should be removed or should not be removed. Because again, as a member of Parliament, he's got a right, especially in the light of the other possible conflicts of interest I might have raised. And the last question to the lady who did the legal opinion, does it also mean that Dr. Letlape, when the matter is brought to Parliament and there must be a vote, that he must not participate? And also, does it also mean that each and every member that smokes, that maybe owns any establishment, has got financial interest in any establishments whereby tobacco products are sold, when that matter is before Parliament for voting, before the House, then it means those members should not participate in the voting? To what extent does the conflict of interest in this regard mean? Because in my understanding, based on what you have written and the response from Dr. Letlape, yes, there is a conflict of interest which has been declared, but it is not to an extent whereby Dr. Letlape must be removed from the process. Just like any other person might have a conflict of interest, but it is not to an extent that warrants a removal or warrants non-participation, as in line with the Code of Ethical Conduct of Parliament. Thank you.
Okay. A recommendation from I'm coming to you, Honorable Mutubase. I'm coming to you, Honorable Mutubase. A recommendation, so that I don't lose myself. A recommendation from Honorable Xhego is supported by Honorable Zungula of not completing this work today. Honorable Mutubatse?
No, thanks very much, Chair, for the opportunity given to me. First, I have clarity, but I must declare right from the beginning, I would move into the direction that says this is not an easy matter. And from what has transpired now, there are lessons that need to be drawn. And the first lesson is that we were never asked as members of the committee when this process started to declare our own interests. And I think that could have been the process. Perhaps moving forward, we must learn that that's what we must do in the committee. Because as members of parliament, we are required right at the beginning to fill in the register on an annual basis to declare our own interest. And suffice, even if it was myself, I would have said that is enough. And for a member to come into the committee and say right at the beginning in the process, because there was no guidance, that now that guidance comes in now. And I don't know what informs that. It's unfortunate. And I'm saying it's unfortunate because the timing of raising this particular matter and the administrative processes that were followed. Because one of the things that I want to ask the legal advisor is, what is the causal factors of drafting this? Because I don't remember if there was any meeting that took place where I participated, and I don't remember missing any meeting. That this matter could have been brought to our attention to say that we are having this particular issue. And on that basis, we could have advised either the secretary or the chairperson to say, maybe we must seek legal opinion on this particular matter, like we're doing now, like we'll do moving forward. I'm saying this, chairperson, because I don't want us to fall into the trap of dealing with hearsays in future. We're a serious institution. We need paper trail. Now, I want to ask just a simple question. What informs? Because the presenter says at the beginning, this is what we received. Is there any document that says that went to either the chairperson or the legal institution to say, we want you to investigate this because this has been brought to the attention of the committee and this is the resolution of the committee in respect of the advice that the legal advice of parliament must give? Because it would be dangerous for us moving forward to deal with issues in this manner. I think that's the first clarity that I would see. But then, what are we required to do? And following on what other members have said, what exactly are we? Can it be clarified and unpacked? Because I've mentioned two issues that in the beginning as members we are expected to. Is a member expected to declare his financial interest? This is what I do. This is what I've done. This is what I've contributed. Therefore, I will not participate. Like Honorable Zungula have said, I'm a smoker. Someone is a vapor. Someone is a poucher. Now, in all those people, we all have interest. But to what extent is our interest that will be conflictual in respect of what members of parliament are expected to do? So those are some of the questions. But I'm saying we must not rush. We must not rush to throwing the guillotine like other members have already concluded that there's a conflict.
All right. I promised Dr. Leroux.
Yeah,
said
so,
your first comment was to Dr.
Yeah,
Leroux.
Thank you, Chair. I'm still here. Yeah, I'm not sure if Honourable Mutubatse had finished his comment or not.
No, I was not finished, Chair. Sorry for the disturbance. I think something to me. So my position is that I agree with the two members, Honourable Sungula and Honourable Teko, that this matter be taken to the different political parties for legal opinion. We must not rush. It's not an easy matter, but I would want to be clarified by the presenter what informs the writing of this document. If there's any paper that was written, because I don't remember making any contribution to that effect. Thank you.
Honorable Dr. Leroux, I promise to come back to you in case it was you raised and you said you, depending on the response, you might want further input to make. Thank you.
Thank you very much, Chair. Yes, I would like to make a little bit further input. So, Chair, I think I'm a little bit concerned for us to say that there has definitely been a conflict of interest because I think that we shouldn't be making that judgment without further investigation. My understanding with the clarification was that the legal opinion is that there might be a financial conflict of interest. And I think that it's very important. My understanding from a conflict of interest that is significant is that it has to be a financial or business conflict of interest, either for the person or a member of their family or a business associate. And so I think it's very important that we now, Dr. de Klappe has written to say, no, there was no financial conflict of interest. I think we need to make sure that that is indeed true. And I think we need to get clarity whether he has received any payment during the last year or 2 years for himself or his NGO from companies, for example, tobacco companies that might have had an impact on these hearings. But I think that there is no way that we can determine that now. And so I think, and I do think that, you know, for example, if I was chairperson of the Rural Doctors Association of South Africa, it's an NGO. If we were to look at a bill, a piece of legislation looking at financing of rural areas, of course, I would be biased and want to make sure that rural areas get a more money, for example. But I think that I have no financial interest in that process, even though I have a previous association with an NGO that is for rural hospitals and rural doctors. I have no financial interest in that specific process, so I would not need to declare that. And so I think that in the same way we need to clarify that, and I don't know how we can investigate that, but I think that is the critical issue that we need to ask. And I just want to also say that Dr. de Klappe I have gone to look at his declared interest as that he declared to Parliament, and part of his public disclosures is that he has declared this link and to this NGO as part of his parliamentary declaration. So I think that has been there. So I think I just wanted to make that point that we need to see if there is a financial conflict of interest or not. But I think that being part of an NGO that stands for harm reduction on its own without any financial interest, I do not believe that is the kind of conflict of interest that the rules have been written for. And I'd really like the legal representative, Ms. Isaac, just to confirm that. Thank you very much.
Okay. Yeah. I will allow Ms. Hugh to respond, but there's a good message coming in from honorable members to say maybe this matter shouldn't and cannot be concluded here because the letter of Dr. de Klappe has just arrived. Can they look into that? And therefore, we also further get all those things looked into before the finalization of that. I'll allow it to come in. But just to correct Honorable Mutubase, I don't know when he logged into the meeting. There is something that is called Chairperson's Forum of all chairs of all committees in the Parliament. I know you don't sit there, so you don't know what will get discussed there. So it was, when I started this meeting, I indicated that what occurred on that day was a bit irregular. I had to report. I can't sit with that information. Now, I don't need your permission to report what I've seen as something that might be. And the committee, this report is saying there might be a conflict of interest. They're probably not definite. So there might be a problem here. I report to the chair, to the House chair. So I didn't need your permission to do that as the chair of this meeting in the chairperson's forum. So it's not the presenter who's going to clarify you that, it's me who's going to clarify you. When I started this meeting, I made that presentation. I took this matter to the House chair into the meeting of chairperson's forum. You probably don't know that because you don't sit in those forums. So that is what I did, not because I needed this permission to do that. Okay. Ms. Isaacs, come through.
Thank you, Chair. Yes, just to again state that the opinion was merely our preliminary views based on the information that was given to us or that was from what happened in the committee. and it was to allow the chairperson or the House Chair to give Dr. Letlapie a chance to respond. Now that the letter has come in, which was just 30 minutes ago, we need to also apply our mind to the letter and supplement the opinion. And Chairperson, a lot of the questions and comments that the members have made, I have noted. And as it has been suggested that we supplement the opinion, then I can answer those more in a substantive way if the chairperson agrees in the opinion, so members have something in writing. This issue is quite a difficult one, and I would also like some time to apply my mind to all the issues that the members have raised and the concerns they have made. Noted. Thank you, Chair.
And I'm glad this meeting is rounding up at the time that I'm close to this. The other part I was just checking that I don't know whether maybe one needs to just get orientation amongst ourselves as to what are some of the duties of house chairs, and what are the responsibilities or chairpersons of committees responding to house chairs. So you don't expect that there's no communication between ourselves. So honorable members, just respect that and know that those things are continuously happening. It's guided by the rules. That is why we continuously have those meetings. But I'm glad this meeting is wrapping up with this to say the legal opinion is going to come through again. Following that, there's a matter coming in from Dr. Letlapie, which they must look into that and support us with that. And there should not be a rush to conclude this matter either or in the light of all those issues. It's a difficult matter, not easy to say it's black or brown. Let us therefore allow the process to unfold and be assisted. So as I said, it's probably, we don't want to apportion any blame to anyone, but the letter of Dr. Letlapie came in 30 minutes ago to me and also forwarded to yourself. We're not really blaming. I'm sure it must have been a difficult time for him, also for the party. Now that it has been received, let us therefore refer back this matter. Our secretary to support us to get this issue to be discussed by the legal opinion. You'll realize, honorable members, that this is a matter important to say, how do we continue going forward in processing the bill, which is listening to the Department of Health, and therefore sit down and give our own views now on a clause by clause, views of our own and views of our party going forward. So it therefore is important to say this matter should stand down and let us be supported by more information and legal opinion in the light of this letter of the Letlapie, and therefore continue in that regard. Honorable members, this being the only matter that was with us, we would therefore want to call this meeting to a close. And thank you very much for your contribution and your direction that you have given to the chair.
Chairperson?
Yes.
Yes. No, I've noted your concluding remarks, but I was going to ask, Chair, if the legal opinion can also include other aspects that would be tantamount to a conflict of interest, not confined to Dr. Letlapie, but for other members, so that if any other member is finding himself within those particular prescripts, then we know, so that we don't come back 6 months later only to find that there's a member that owns a spaza shop that sells cigarettes, and therefore this should have been dealt with.
I don't know whether you are going to reduce it to that level. That my brother has a spaza shop and that others, but there are members here in this platform. Let's leave it at that and see what it has. There are members here who have asked some of the presenters, who's your funder? Because people have just come in to make presentations. This issue is a very sensitive matter, the issue of the tobacco bill. There are people who are for and there are people who are against. There are people who are funding this other type and there are people who are funding the other type. So it always amused me who is coming in from which platform asking who's funding you, because whoever is asking that question is obviously having interest to know why is this party, this side, so strong to have views for or against tobacco. So those issues again are issues that you can raise if you so wish, but I'm not going to really think we have to now create a terms of reference. Members know themselves. If there's any conflict of interest, anytime the parliamentary rules state that very, very clearly. It states that very clearly. You suspect you must err on the side of, I don't know, let me ask and declare. And people are going to say, no, but this is trivial. You don't come in and say, no, I did not know. You err on the side of declaring, and somebody is going to advise you should not have declared. This is nothing. So if you want us to do all that, my brother-in-law has a spaza shop, and therefore I should not have been part of this. It's another. We should not stretch it too far. Your personal interest and your immediate family's interest on any issues, you declare that on Parliament, done. Not because there's a tobacco control bill only. It's just the matter as what the rules say. Okay. Thank you very much, honorable members. The meeting is adjourned until we can hear the progress. We will not be able to proceed too much on the tobacco control and electronic delivery systems matter until and unless this matter is behind us. Thank you very much. Because we need to know we are legitimate having Dr. Letlhapeh with us, or we have had a situation that says he's not going forward with us, or then what happens when he has been with us over the past years and months. Okay, thank you very much. The meeting is
Thank you,
adjourned.
Chair.
Thank you very much.
Can I,
Meet
sorry,
tomorrow.
Chair, to interrupt. Could
Yes,
I just
sir.
ask one question before we adjourn? I didn't get a sense of how long this process would take for a legal opinion to be given. Could we get some indication of how long it would take to get that for the legal department to look at this and give us an opinion?
Let's get the response tomorrow. If they can't just standing in like
Okay.
this and you could be able to say that they're going to. It's not going to be possible for anybody. I mean, if I were to ask you to tell Leroux, how soon is this patient going to get better on this pneumonia? I don't think you will be able to tell that. Why don't you give this professional space to work on this and then come back to us? There shouldn't be. We can't
All right.
rush because they'll confirm. They will say tomorrow, and then when they are not able to do it tomorrow, you then accuse them why they didn't bring it. Let's give them time. They'll bring it up nicely to us, and we'll come to here. We'll meet tomorrow, and maybe we can be advised if there is process is going to take longer than a week or something. Ms. Isaacs, you'll probably be able to maybe directly to Ms. Machalamba or to myself indicate how you could assist us, how long it will take. I don't think it's fair to ask you now to do that. Okay, thank you very much. The
Okay, thank you,
meeting is
Chair.
adjourned. Thank you.